People are wondering why the legal plan I proposed to bring Trump down has not been implemented. Certainly by now, congressmen and senators are aware of the plan. Some say the Democrats are too cowardly. Some say they're in cahoots with Trump. I believe those who voted to impeach Trump in the House and Senate are simply unable to envision how my plan would play out. Let me draw a picture. It is without question that those who voted against impeachment gave aid and comfort to Trump. The 14th Amendment specifically mentions senators and representatives and allows for no excuse for such conduct. The congressional record identifies those senators and representatives who are disqualified just as surely as a death certificate identifies who is unable to serve because of death. Both of these occurrences are covered by Rule 20, Clause 5D of the Rules of the House of Representatives. When someone dies or is disqualified for associating with an insurrection, the determination of a quorum must be adjusted accordingly. This simply means that a majority of those representatives and senators, minus those disqualified for voting against impeachment, constitute a quorum and can proceed with the business of governing. Following the Supreme Court guidance set out in Powell v. McCormick, representatives and senators should enter into the journal of its proceedings how they arrived at excluding the members who voted against impeachment. The very first order of business after electing a new speaker or leader should be a vote to disqualify those 5 Supreme Court justices who gave aid and comfort to Trump. These very same Supreme Court justices ruled that a duly constituted Congress can enact that legislation. Meanwhile, Trump, Johnson, Thune, Bondi, Patel, and Miller meet in the Situation Room, where after 15 minutes of listening to Stephen Miller throw a fit, they decide to ignore what has happened. Meanwhile, the 5 disqualified Supreme Court justices are fully aware of the threat to their jobs and decide to initiate legal action in the United States District Court. They sue to keep their jobs. As their cases make their way through the legal system, those justices will be forced to recuse themselves pursuant to 28 U.S. Code 455, since the conflict of interest is so obvious. They won't be allowed to decide the right or wrong of their dismissal. Their fate will be in the hands of the remaining 4 justices. The newly formed Congress legislates on the disqualification of Bondi, Patel, Hegseth, etc., and sends it to Trump for his signature or veto. Meanwhile, the old Congress is called into session by Johnson and Thune. The House Minority Leader and a senator raises a question of privilege, challenging the qualification of one of the 192 representatives and one of the 43 senators who voted against impeachment. This question of privilege requires both houses to stop all other business and schedule debates before a vote. Someone will raise the issue that other representatives and senators who voted against impeachment must be recused from voting due to the obvious conflict of interest. Meanwhile, the new Congress passes legislation to declare Trump disqualified to serve as president for inciting an insurrection and pardoning those who participated in an insurrection. Meanwhile, Mike Johnson, as Speaker of the old House, and John Thune, as leader of the old Senate, wrongly declare there is no reason to recuse those members who voted against impeachment. At the conclusion of debate, the majority of members in the old Congress, including those who voted against impeachment, vote against disqualifying the subject of the question of privilege. Meanwhile, several states recall those members who were declared disqualified by the new Congress, depleting the majority of the old Congress both in the House and Senate. Meanwhile, Mike Johnson and John Thune try to continue with business when another question of privilege objecting to the disqualification of another member in each House who voted against impeachment is raised. Meanwhile, pursuant to Article 2, Section 1 of the Constitution, the new Congress may provide for the removal of both the President and Vice President for their inability to discharge the powers and duties of the office. The new Congress does so and gets to pick an officer, not necessarily the Speaker of the House, to act as President until the disability is removed by a 2/3 vote of the new Congress. Meanwhile, the old Congress, minus several members recalled by various states, struggles with another question of privilege requiring debate and argument before resolution and before the old Congress can do anything else. Meanwhile, the new Congress votes to end the Obamacare crisis, the turmoil at the Department of Education and the Department of Health. Meanwhile, the new Congress puts an end to the tariffs and recalls the military from occupation of our cities, and so on, and so on. It is tempting to wait and endure the destruction of our democracy, hoping that in another year the power of impeachment will save us. The 14th Amendment and 18 U.S. Code 2383 were developed to address this precise situation. The statute of limitations for criminal prosecution against those senators and congressmen will pass on January 6th. Irreparable harm will be done if this plan is not implemented. Our leaders must affirm to the citizens of this country and to the world that we are a country dedicated to the rule of law.